And judges, feel free to introduce yourselves.
Thank you, Hannah. Good afternoon, everybody, and congratulations on participating in the We the People national competition. We hope you enjoy the experience, and I think it'll be a really worthwhile experience for all of you. We're going to introduce ourselves, ask you to introduce yourselves, then I'll read the question, then we'll hear your opening statement, and then we'll ask you some questions and conclude with some feedback. My name is Dan Taubman. I'm a senior judge on the Colorado Court of Appeals in Denver, Colorado.
My name is Ali Khan. I am an attorney in Chicago, as well as an alum of the program, representing the state of Illinois at the national competition back in 1998.
My name is Ben Glickman. I'm also an alum of the program. I represented California at nationals in '95. I also spent a year in Phoenix, and so I judged all the Arizona competitions back in like 2006, 2007. So, which school are you from? Oh, sorry, you're all muted.
We're from Hamilton High School.
Oh, yeah, I judged that school way back then. Anyhow, in my day job, I work for the California Attorney General's office, and I'm just thrilled to be here. Thanks.
Would you like to introduce yourselves to us, please?
Hi, I'm Shrika Kantala.
I'm Manvi Harde.
I'm Michael Chen, and we're Unit 3 for the Arizona Wildcard team.
And would you introduce your teacher, please?
Oh, and our coach is Brianna Willits.
Okay, thank you. Welcome to you all. We're going to ask you about question 1 now, which I will read. I do not think the United States would come to an end if we lost our power to declare an act of Congress void. I do think the Union would be imperiled if we could not make that declaration as to the laws of the several states. What impact has judicial review had on federalism? Is judicial review a counter-majoritarian practice? Please support your position. What limits, if any, would you place on the practice of judicial review? You may begin.
In Federalist 51, Madison analyzes the system of checks and balances that divides power between the 3 branches of government. This was written in response to concerns spurred by the Enlightenment philosopher Montesquieu's writing that despotism was the primary threat in government.
Judicial review allows courts to overturn unconstitutional legislative and executive actions. The levels of judicial review include rational basis, intermediate scrutiny, and strict scrutiny, differing on the importance of the issues they address.
Judicial review limits the unconstitutional expansion of federal powers, checking the legislative and executive branches while preserving federalism. In the 1995 case U.S. v. Lopez, the Supreme Court struck down the Gun-Free Schools Act as it violated the Commerce Clause of Article 6, Section 2. This restricted Congress and thus maintained the state's 10th Amendment rights. Furthermore, the 11th Amendment established the sovereign immunity of states under judicial review, affirming Justice Iredall's dissent in Chisholm v. Georgia that states could not be sued under federal law.
However, judicial review impacts federalism more by strengthening the federal government. In Obergefell v. Hodges in 2015, same-sex marriage bans were found to violate the 14th Amendment's equal protection and due process clauses. This exemplifies the incorporation doctrine by which the federal government incorporates the Bill of Rights to state governments. After the court incorporated the Second Amendment in McDonald v. City of Chicago in 2010, only the Third, Fifth, and Seventh Amendments remain unincorporated.
Unlike the other 2 branches, the federal judiciary is appointed and violates popular sovereignty, proving to be counter-majoritarian by overturning majoritarian opinions. In the 1989 case, Johnson v. Texas, the Supreme Court held that flag burning was legal under the First Amendment, clearly counter-majoritarian, as 3/4 of the American people, according to Pew Research, opposed flag burning as recently as 2006.
Judicial review reflects the will of the people, since federal judges are appointed by the president under Article 2, Section 2. The framers of the Constitution designed the federal courts to support the nation's democratic republic while protecting individual rights. Since the president is elected by the Electoral College under Article 2, Section 1 and the 12th Amendment, appointed judges reflect the people as the president is chosen under the trustee theory of representation.
No limits should be placed on judicial review. Despite its shortcomings, judicial review promotes ideas such as equal protection under the law with the 14th Amendment. In addition, the principles of stare decisis and the presumption of constitutionality until a lack thereof is proved beyond reasonable doubt ensure that the Supreme Court remains reactionary and cannot act independently.
I disagree, as judicial review should be completely abolished, as courts override the will of the people. In Brutus 15, the Anti-Federalists posit that the appointed Supreme Court would be exalted above all other power in the government. Thus, judicial review impairs the public's ability to engage with the Constitution. The court is now a political instrument, often undermining democratic institutions on behalf of interest groups, which is evident through the case Citizens United v. FEC.
Thus, certain limits can be placed on judicial review to make it more fair. Courts should only exercise intermediate and strict levels of scrutiny. In Craig v. Boren, the Supreme Court used intermediate scrutiny to establish that different drinking ages for men and women violated the Equal Protection Clause. Likewise, in the landmark case Cooper v. Aaron, the court used strict scrutiny to uphold the decision of Brown v. Board of Education, when the state of Arkansas tried to undermine its ruling, both crucial decisions to ensure equality.
Judicial review allows judges to review legislative and executive actions. While not explicitly in the Constitution, it is an important practice that often inspires debates over its constitutionality and effects on federalism.
Thank you for your opening statement. Let me start by asking you to follow up on your discussion about the standards of review of rational basis, intermediate, and strict scrutiny. When the Supreme Court decided the United States v. Lopez case that you mentioned, did it apply any of those standards?
Yes, I believe that in U.S. v. Lopez, the Supreme Court applied strict scrutiny because this involved people and their rights this involved states' rights directly as a result, since the Congress had passed the Gun-Free Schools Act as a consequence to try to limit guns in schools, which may seem like a good idea. However, this is not a power that Congress has, and thus it was struck down.
I thought that strict scrutiny applied to cases of racial discrimination and things like that.
Yeah.
Can I ask a different angle on the standards of review? So I think if I heard you correctly, you said that the court should only exercise intermediate or strict scrutiny, but doesn't that mean it's going to be harder for state laws to survive? If they're subject to heightened scrutiny, they're more likely to be struck down. So isn't that going to undermine federalism more, or did you mean something different?
So our reasoning behind making sure judicial review is a more fair process and using only intermediate and strict scrutiny is because the rational basis test of judicial review doesn't really pertain to important problems such as gender discrimination or racial discrimination. Important landmark cases such as Brown v. Board of Education, Plessy V Ferguson have changed the entire sphere of American society. And the rational basis test, some can say that by using that form of judicial review, the Supreme Court is overusing their power, and that using the rational basis test can be seen as judicial activism, as those issues don't necessarily pertain to protecting the most important rights of the American people.
So the idea is they just wouldn't decide cases that ordinarily would be decided on a rational basis. They would only focus on the big issues. Got it. Okay, thank you.
One thing, I thought I heard you talk about the political nature of the Supreme Court. With that said, do you think, therefore, the justices should be term limited? Why or why not? And we can go from there. So let's start with that question.
Yes, as the judges are appointed by the president, therefore, in a sense, the Supreme Court, in a sense, has become more and more political. However, we have also seen that in cases that have been overturned, such as in Lawrence v. Texas, which overturned Bowers v. Hardwick, which essentially allowed for the idea that sexual privacy was a constitutional right. Therefore, this new sense of different Supreme Courts will essentially they have more modern interpretations of different cases. Therefore, I do believe that that the current way that the Supreme Court works ensures that it checks itself on previous cases in order to ensure that modern interpretations are used.
Well, that is a good point. Some may argue that the Supreme Court justices should have term limits or should serve a set term. As we did mention, the court has become slightly politicized, even though the original intent of having life terms was to create an apolitical court. As we've seen in the past few years, it has created political issues, especially as a simple majority in the Senate can nominate and approve a justice to the court. So we see that because of this, I propose a rotating Supreme Court, similar to our current Federal Reserve, where justices, we could keep 9 justices and they would rotate on a 2-year basis. So each justice would serve 18 years. Thus, over their 18-year period, they are still not technically affected by the political and outside factors. They can focus on being judges while not spurring the debates that force presidents to try to force judges through the system just so they can have the influence for a long time.
While my teammates make excellent points about the Supreme Court turning into a political instrument, I would disagree because, as seen in the Supreme Court rejected a bid from Texas Attorney General, this bid was supported by ex-President Donald Trump, and that bid basically said that the ballots of millions of voters that were in support of President Joe Biden should be discredited. And the Supreme Court, and even though ex-President Donald J. Trump did support this bid, the Supreme Court rejected the bid completely, and that showed many people believe that the Supreme Court is under the political instrument of the president, but this is a very keen example of why that is not true. And the Supreme Court does follow the principles of the Constitution to maintain the common good of American society.
So then would you be against term limits then?
Sorry, could you repeat that?
Would you be against term limits?
I wouldn't be against term limits, but I think a common misconception is the Supreme Court is a political instrument and that they are just under the president, the executive branch, but that's not true. The Supreme Court has a voice of its own and it accurately follows the Constitution.
You mentioned in your opening statement some cases where the Supreme Court had supported minority rights and therefore it was counter-majoritarian. Are there examples that you can give us where the Supreme Court has not supported minority rights?
To clarify, would you like examples of cases that are counter-majoritarian that do not support minority rights? Or
no,
just
the opposite. Cases where the Supreme Court has not supported minority rights and that therefore would not be considered counter-majoritarian.
Yeah, so one of the cases we see is Plessy V Ferguson, which established the separate but equal doctrine that segregation was legal and constitutional as long as the facilities provided were equal. And even though now looking back on it, many of us may see that this was an unfair decision, this decision actually accurately reflected the attitudes of the American people at the time, as many states, including those in the North, did have laws similar to Jim Crow laws or discriminatory laws that discriminated based on race.
We can also see an example from a court case at the state level with Arizona, with Russian Nib Studio LC versus City of Phoenix, in which the Arizona Supreme Court essentially issued that a wedding studio's claims that its religious beliefs under Arizona's Free Exercise of Religion Act allowed it and entitled it to disregard a civil rights ordinance mandating equal treatment of Americans regardless of their sexual orientation. Therefore, the state of Arizona essentially ruled against the minority in this case.
Okay, thank you. Your time is up. Thank you very much. Let's show our appreciation for the team.
Thank you.
Let me start by giving you a few comments. I thought you did a very nice job. I think that your initial discussion of Federalist 51 and the Madison's refutation of Montesquieu was good. That your example of United States v. Lopez was a good example. I'm not sure that the Supreme Court decides cases always on the basis of rational basis, intermediate scrutiny or strict scrutiny. I think that's only for equal protection or some due process cases. And for example, in the US v. Lopez case, I think the Supreme Court could just say that the statute that was involved there was contrary to the Constitution. So that's a different standard, but that's relatively minor. The examples that you gave of counter-majoritarian decisions like Obergefell and Johnson v. Texas were good examples. And then when I asked you of examples going the other way, Plessy v. Ferguson was a good example. The Arizona case you mentioned, I'm not familiar with that, but that sounds like a good example. Also, you might have mentioned the Korematsu decision from the Supreme Court about Japanese internment during World War II. Overall, I think that and also you mentioned in terms of intermediate scrutiny, the Craig v. Boren case, and I thought that was another that was a good example of intermediate scrutiny being used. So overall, I think you did a very nice job.
Again, let me start off by saying, congratulations again for being here. I know it's not always easy, so be proud of yourself. Just to build upon what my colleagues said, I love the way you all participated, how you disagreed with each other, showed a thought process. When we get the term limit question, I really liked how you gave the example of the Federal Reserve and the rotating cast of folks. Because again, to me, I think one of the most important things is showing a degree of thought process behind something, and you always did that in a logical manner. So I thought that really stood out to me, and I really appreciated that. So yeah, overall, great job.
Yeah, I would agree with everything that's been said. I thought the prepared remarks did a nice job of answering the questions. I like the notion that appointed judges are not entirely outside of popular sovereignty, right? They're appointed by presidents and confirmed by the Senate, so that they're not entirely beyond the people's influence. I like that. You said some provocative things. I think somebody said no limits, somebody said completely abolish it, and then somebody came down somewhere in the middle. I would have loved to have more time to talk about the completely abolish it, because what happens then? That's a whole different ball game. But we didn't have time to address that. On the should only apply intermediate or strict, I think we got there in the Q&A. It was a little unclear to me what you meant in your prepared remarks, but I think your basic point once we got there, that it should only be getting involved in cases of fundamental rights or the real meaty issues. It shouldn't be deciding some contract dispute or whatever. That I think is a reasonable position to take. So the one piece of constructive feedback I would give is there were a couple times, and I think the term limits question actually is a good example of this, where you started answering and I didn't know what your answer was. And so this is something I tell junior attorneys all the time. Start with a yes or no and then explain, rather than explain and then say, and that's why my answer is yes. It's always helpful to tell the judge, yes, there should be term limits, because no, there shouldn't, because, and that would have made that answer even that much stronger. But overall, I thought you guys did a very nice job. So good luck